Pardon, sit down, please, sir.
Just key.
Pardon?
Just key.
Just which?
Key. I'm here to correct a mistake by the court.
Well, first of all,
The court has made a mistake.
are you Wilford Keith Thompson?
No, that's not what I normally go by now.
Can I see the information?
That's a fictitious entity in terms of person legally speaking, so. I've tried to clarify this a few times, but apparently the level of the property.
So your name is Keith Thompson?
My name is Keith, that's all. Nothing more, nothing less.
You don't have a last name, sir?
I have a family name, clan name, but that's irrelevant today.
So you are not Wilford Keith Thompson?
Okay, one more time, on and for the record, I am Keith. Nothing more.
And sit down, sir. I'm looking for a Wilford Keith Thompson. Please sit down, sir.
Actually,
Please sit down, sir.
Sorry. Can't do that. I served into the court this morning.
Sir, I'm looking for a Wilford Keith Thompson. You are not that
This is
person. Sit down, sir.
bailiff.
Please remove this gentleman from the courtroom.
Thank you. That's the person you're looking for.
Please,
Sir, that is the person. I'm trying to remedy things. Touch me and you will be charged. I'm a peace officer. You want to dishonor a court official?
The defendant's on the bailiff's desk.
Sir, are you here on behalf of Mr. Thompson?
I said I was the administrator to that account.
Are you here as agent for
Could you
him?
guys please back up? Thanks.
Are you here as agent for him?
Not as agent, as administrator, much like you are administrator of this court.
Sir, you're either him or you're here as his agent.
As his
Speak on his
administrator.
behalf. Are you either of those?
Yes, it's lawful.
Pardon?
Yeah, he's in common law jurisdiction, which I established as soon as I came in here this morning and reestablished again. The bailiff understood me. This other bailiff, wherever she went, she understood me as well. And this gentleman doesn't like talking.
We're gonna take a recess. Thank you.
Thank you, all rise.
How long?
How long, sir? I don't have all day, thank you. I have things to do.
We'll take the court.
Yeah, actually,
This court will recess.
please note that the judge has abandoned the court. It's abandoned ship, and I, as the sovereign in this room, claim authority, case dismissed with cause and prejudice. Have a nice day. See you later.
That's the way it's done.
I was over on Sovereign Soul Unchained Mind, breaking down more of that California fire. Yes, that is an interesting video. See, he knows exactly what I try to teach you on this channel. He said, I'm not his agent, I'm his administrator. And of course, he's talking about the estate or the LEI that they have, the trust, the constructive trust that they've created out of the estate, right? Out of the property of the estate that he is assumed to be a trustee of. And he says, no, I'm not the estate, and I'm not an agent of the estate. I am the administrator. But the problem with that is that he should have said executor, because the judge is an administrator. See, an executor is appointed by will, and an administrator is appointed by necessity of law, which means someone died without a will. And this actually ties into the fire thing. If you going on over in California, if you guys have not caught my my stream yesterday morning, I believe it was, right? Days kind of blend together in third shift, you know. But if you have not caught my stream yesterday morning, I really gave much the same presentation I'm going to give tonight, but applied it to the fire, except for, of course, I'm going way more in depth tonight. So let me say hi to the folks in the chat. Let's see, who do we have so far? We have Dylan Heron, good to see you. William McLean, good to see you. Bullet, good to see you. Kevin C, Peg's Place. Scott NYC, good to see you guys. Theo Shen, of course, Make Stupid People Famous, said he's out of data, so he'll be back next week. He'll catch up. Gonna have to make some more moderators, I think, because he's pretty much the only one that I got right now. So, Benji Boodles, I'm glad you've been enjoying the shows, man. Thank you. I put a lot of hard work into this. I've researched, to the detriment of myself, and my wife actually got quite irritated with me for a long period of time where I was spending 8 to 10 hours a day when I was home just going through old law. And I've spent a lot of time and effort. It's taken a lot of hard work to figure out exactly what they're doing and how they're doing it. But I guarantee you that what I teach you is exactly what they're doing and how they're doing it. And I challenge you to bring any lawyer to have a conversation with me. But I just showed you a video of that man making the judge walk out of the courtroom, abandoning the court because he refused to agree to be the infant trustee and to be administered by this special administrator, this black robe pirate. So this is part 2 of the Magna Carta. If you've not watched part 1, please go back and do so. Otherwise, some of these things may not make sense entirely, but I will give a brief recap of last weekend's show. What's up, Ryan 1778, Gregory Top? You guys join the chat. Good to see you. All right, so recap, essentially in England, and we're going to get the history. You can't learn law without learning history. So England prior to 1066 was generally self-governing. Okay, they'd been invaded by the Vikings in, I believe, the 800s AD, and the Vikings brought with them the concept of the power is derived from the people. The just power of the king or the government in general is derived from the people, and they carried that forward. They had, at the time they were conquered by William the Conqueror, they had what was called hundreds, which were similar to counties, but not quite as big. It was basically like large neighborhoods, if you will, where the men of the 100 families would get together and they would hold court and they would settle the problems and disputes internally using common law that was never written down. It was considered an abomination to write down common law because men can lie. It gave man the opportunity to lie or be deceitful with his words. On the paper, or like we see today, change meanings later, or they'd never really changed the meaning of the word. Instead, they changed the people's understanding of what the meaning is. And that's how these words get locked away in legalese, because they didn't invent a new language. In fact, the words are more etymologically sound in a law dictionary than any other dictionary, because this is where the law is entirely in the sphere of the spiritual. So, brief recap. 1066, William the Conqueror conquers England, brings what's called the Domesday Book. It's spelled Domesday, but it's the Doomsday Book. And this is a system of registry where he forced all the British barony and everyone to register their property in the Doomsday Book. And what that did was that created essentially a split title where the crown had a superior interest in the property. And then he introduced the divine right to rule by kings. And then, of course, claimed that, the entire authority of being a king comes from God and all the land belongs to the king. And this introduced feudalism into England. He also split their courts, made sure they were no longer self-governing. And in the he split it into a temporal, meaning worldly, and a spiritual court. And the spiritual court he gave to his priest class that he brought with him, because he was under Roman civil law. That's what he brought to England. Difference between common law and Roman civil law is common law is based on the laws of nature. Civil law is essentially the decrees of private conscience. Okay, so we'll get into that, because we're going to get all the way up into how this ended up in the United States and where we are today. So the spiritual court had authority over all things. Thanks, John. John Keeley said my favorite channel. I'm glad. So the spiritual court had authority over all things regarding life and death, right? Property, inheritance, stuff like that, because those matters are the spiritual matters, right? So it didn't take long before these courts started, usurping and stealing the property from the estates of the barony. So say, because at this time you also had you had wars going on, stuff like that. So say the baron went off and was fighting a war and he died and his son was not of age, right? Then his estate would come under administration of this spiritual court, ecclesiastical court, until such time as the heir came of age and was able to claim the estate. But a lot of times they were giving it to their friends. They were stealing from it. They were doing a bunch of crooked stuff. This is what motivated the Magna Carta. So when the church went off on a conclave and left King John by himself defenseless, the barons cornered him at the battlefield known as Runnymede. And that's kind of what I made a little AI generated image of as the thumbnail. That's King John being surrounded by the the barons at Runnymede, right? Or is an approximation that Grok can do anyways. But they had already wrote up the Magna Carta, and they forced King John to sign it. And in the Magna Carta, we'll do a brief overview again of that. I just want to point out that all of this comes back to property and estates. All law is the protection of property. That's it. All law. Because you can think about it this way: all crime is theft. If you kill somebody, you stole their life. If you violate somebody in a grapey way, right? You have taken away their volition, their free will to do with their body as they please. Same thing if you assault them, just punching them or whatever the case may be. If you steal from them, obviously that's theft as well. So all crime is theft, and all law is regarding the protection of property, whether it be your body or the things you own. And it basically boils down to this, because property itself is an extension of your will. You will something to become your property. Okay, it is the ultimate realization of your will. You make something your property, you will something to be your property because to serve your purposes, right? To serve your will, to serve the same way that your hands, your arms, and your legs, they serve your body. You make something your property to serve your will. And it's funny, in the very first part of the Magna Carta, you'll see, which you'll notice when I bring this up, it's in the Michigan compiled laws. And the reason it's in the Michigan compiled laws is because it's the very foundation of their jurisdictional authority to administer our infant estates. So you'll notice he says, it says right here in the very beginning, the Church of England shall be free. Hold on, there's one part where he says, we will it to be, and that's the terminology they constantly use. Yeah. And we will have them so observed. And the word will means, before the discord between us and our barons was granted of mere free will, right? This charter we shall observe, and we do will it. That's what I was going to be. And we will it to be faithfully observed by our heirs forever. Okay. And we will it. So that's the whole thing about property. If you leave your property behind without a will, then it's considered intestate, and it escheats to the state, and it comes under administration. And we went over escheat in depth in the last video. I'm not going to be able to recap everything for you guys, but escheat is essentially when by some accident or chance there is a break in the descent of property, meaning from the owner to the heir. Okay, when something escheats, that means that instead of going to the heir, it reverts back to the grantor or to the crown or to the state. And that's what escheating means. And so if you die without a will and you do not have an heir that is of age, your property will escheat to the state. And that's why they presume you to be dead or missing when you do not claim your estate within 7 years. And that's, most people know that of the Set the KV Act, or at least people who've been in this area of study for some time. But this goes all the way back here. And the very first thing they start talking about is heirs and inheritance and estates. He shall have his inheritance by ancient relief. That is to say, the heir or heirs of an earl for a whole earldom, etc., etc. So I'm just bringing this up to show you. And of course, we went over this much more in depth last time. This is the basis of law. Law is your property. Your standing in relation to your estate. Your estate is everything you own at law. That's a substantive definition, right? Substantive definition is everything you own at law is your estate. And your standing or your status is your relationship to that estate, whether you have absolute title. So if you look at property as being an extension of your will, then you could say that the ability to acquire, possess, and dispose of property freely is free will. If you are unable to do that, or if somebody else tells you how to use your property, you no longer have free will. And that's called being indentured or a slave, depending on the circumstances of it. Right now, you could say we're debt slaves, but accurately, we're just highly indentured to the Federal Reserve System. And that's what we're going to get into today, is how they did that, right? So we'll go right here. And of course, the Magna Carta was necessary for them to escheat our estate. And Michigan particularly had this in mind the entire time. This is the Michigan compiled laws from 1929. Michigan had this in mind the entire time. Now, the Magna Carta is above even the Declaration of Independence in this particular volume. And this is also the first Michigan law book that was called compiled laws. And the reason being is because they blended the jurisdictions here. Most of the state was under administration, if not all. So they were now able to begin moving things over into probate. Geez, there's a lot of pages here. I'm trying to get up to where it shows you the table of contents. But part two, we're getting close, right? Title, and this is probably one of the longest compiled laws that they're actually, or one of the longest law books that they have, but this is where they introduced the probate code. So probate is that ecclesiastical jurisdiction. I don't know if I probably forgot to mention that. That is what it's become. It was called ecclesiastical. Now they'll never admit that it's ecclesiastical, even though the judges are under canons. That's what judges' laws are, their canons, judicial canons. And they are ecclesiastical, and it is all probate at this point in time. It was not always. And the genius of doing this is by making, in the United States, by making common law the fundamental law, just as it was in England for freemen, the fundamental law of our country. They didn't actually have to put anything about probate or that ecclesiastical jurisdiction into the Constitution or in any other founding documents of the state or federal government, because everyone at that time knew that jurisdiction was part of common law. The administration of infant estates, of incompetents, and of heirs who are, well, that's what an infant is heirs who are not of age, right, or who are incompetent. And so let me show you guys this. So here, if you guys can see, it says Magna Carta, number 1, Declaration of Independence, number 2, Constitution of the United States is the 3rd, right? And so once we take the little blinder guy off, the compiled laws of the state of Michigan, 1929. And they needed the Magna Carta to be first. Why? Because, and this is in 1929, this is what they had been working towards since Michigan became a state. If we take a look at, let's see here, I didn't pull that up. That was kind of dumb. But so I'll just go through it verbally. I've shown it on other shows. So in 1827, before Michigan even became a state, they created their probate court and the revised statutes of the territories of Michigan. They became a court, or they created the probate courts. And then in 1835 or 36, I believe it was, that's when they gave license to the probate court to sell the properties of minors under administration. Okay. And then they built it up from there, creating reasons of why they could escheat and take the property, leaving it to Michigan had something called overseers of the poor. So anytime somebody went to go get a benefit from the overseer of the poor, just like welfare mooches do today, you know, and complete offense if you're a welfare mooch, unless you actually need it, because that's one of the biggest problems with our society right now. And that's how they get you under administration. As soon as you go to accept a benefit, you forego your sovereignty and your inheritance to your estate. And everything is all about estates. You're like, why does this guy keep talking about estates? Because you're supposed to have a house, a seal, right, that governs your estate. The very first layer of political protection and the very first political subdivision of a state is the estate. It's the house that controls the estate. I'll show you guys. And these territorial acts, the organic acts of the territories, an ordinance for the government of the territory of the United States northwest of the River Ohio. Okay. And what this says is the very first thing, it says, be it ordained by the authority aforesaid that the estates, both of resident, not, and immediately starts going into property, estates, the descent of estates, right? So it says the estates of both resident and non-resident proprietors in the said territory dying intestate. Quiz, what's that mean? Means without a will. All right. So immediately and this actually is a good ordinance because it keeps it from going directly to the court first. See, now if somebody dies intestate, it goes to the court automatically. And shit, even if you do have a will, it still goes to the court in a lot of cases, you know, and that's not the way it's supposed to be in these territories. And here it goes to blood, right? And there shall be in no case be a distinction between kindred of whole and half blood, saving in all cases to the widow of the intestate her third part of real estate for life and 1/3 part. And see how this is exactly like the Magna Carta, and the Magna Carta was written 600 plus years before this document right here. There's a reason for that. Common law is largely unwritten, and most of common law and the customs and usages in common law after it was written in the Magna Carta were determined by the case law. And because it's not founded on judicial discretion, the judge has no judicial power. He's not a judge. He's a magistrate, first of all, at common law, and he's like a referee, and he has no tribunal authority, meaning he cannot make any decisions. He does what he's told at common law. There's no judge. It's just a magistrate, right? Unless, no, and that's it, because the jury is the judge. And that's a tough thing for people to understand, but that's how it works. And that's how common law stayed basically unchanged from 1215 all the way to, when was this written? The territories, the acts of the specific territories. Well, we know it was entered into the library in 1911, government printing office, but they weren't obviously written in 1900. Whatever, it was before Michigan became a state, so it'd have to be 1810s, 1820, something like that. And so from 1215 to 1810, 1820, whenever this was actually originally written, the ordinance, and I should know that, I'm kind of embarrassed I do not, but unchanged law. And it all has to do with the state and inheritance. So how do you end up in the other jurisdictions? How do you end up in civil law or any of the other jurisdictions? Well, you end up in those jurisdictions through contract. So there's 5 jurisdictions of American jurisprudence. And generally in any common law country derived from English common law, there's 5, because the video I showed at the beginning of this was a Canadian, and he can use the same stuff, right? Because it all goes back to the original common law of England, which has to do with blood and kinship and inheritance. And that's it, because all law is about protecting property. So without expounding on that too much, there's 5 jurisdictions of American jurisprudence. The word jurisprudence means law, essentially, right? But if you break it down, juris, law, prudence is a habit of being wise. So it's law, wisdom, jurisprudence. And those 5 jurisdictions are common law, obviously, is the default. It's the law of sovereigns. So when the Clinton administration sued the Russian Federation for election tampering, they sued under DC common law, which I had never seen before. I have the document in my files, and I should have brought it up, but they sued under DC common law, and they sued for trespass on chattels. And obviously what that means is you interfered with our election by influencing our chattels. You trespassed on our chattels. And that's actually the case that was filed by the Clinton administration against the Russian Federation. And because it all goes back to property. Now, so common law is the foundation. It's the law of sovereigns. Then you have civil law. Civil law is contract, okay, contract law. So it's the law of private conscience. But in this republic, it's meant to conform to common law. So what do you mean? So say you go into a municipality and you want to live in a town instead of being a farmer, right, and start a business. Well, you contract with that municipality to be a resident of that municipality, right? And as such, they have municipal ordinances. Now, these are man-written laws, but they're supposed to conform to common law. And that's where Marbury versus Madison says any law repugnant to the Constitution. What it really should say is any law repugnant to common law, any statute repugnant to common law is null and void. Okay, so that's civil law, and that's how you end up you have to contract to end up into civil law. Then you have maritime admiralty, which is the law of ships and vessels, international trade, lex mercatoria in a way, right? And then you have military law, and you have to contract into that as well. You have to contract with the military. But the last jurisdiction, you don't have to contract, and that's probate, and that's the unspoken jurisdiction, the one that was grandfathered in. And because of that, they can presume that's why you don't have to contract to be in with them. Sorry, I lost my train of thought for a second. You do not have to contract to be in that jurisdiction. They can presume or make a claim that you are an infant, or presume and you don't rebut that you're an infant, or you're a spendthrift, or you're a drunkard, or you're some form of incompetent, right? And then they can take your estate and administer your estate and only allow you bits of it, and the property that you have, they tell you how to use it. Now you guys are probably thinking, well, how are they doing that? No, it's UCC. No, it's Maritime Admiralty. No, it's this, and all the same shit that people think that, they haven't come across this very important information. Well, let me show you something. This is Title I, Section 8 of the United States Code. And it's the definition of person, human being, child, and individual, as including born alive infants. And now you got to watch, this is how they do their statutory construction. Okay, they say, in determining the meaning of any act of Congress or of any ruling, regulation. So that means anytime you see the word person, human being, child, or individual. Okay. These words shall include, and in statutory construction, when they say shall means absolutely without a doubt all the time. Include means excluding everything else. That means these words only mean this. And it means every infant member of the species Homo sapien who is born alive at any stage of development. So infants are under administration. This means all 14th Amendment citizens subject to the jurisdiction of Congress, being the United States Code, are all infants. Is everybody with me here on this? Let me know, anybody in the chat, if you guys do not completely understand this. And Brad and Tasha are here. Good to see you. Chicago Cubby Bear popped over. Good to see you. And let's see, didn't they? Ryan 1778 says, didn't they have something that they passed in 12? No, they didn't. They did so what happened and after that is that King John went and complained to the Pope, and the Pope was like, oh, well, they made you sign it under duress. But then those two actually died, I believe, within a year of the signing of the Magna Carta, mysteriously. And the following king and the following Pope both confirmed the Magna Carta, and the Confirmare Cartara. It's called Confirmare Cartara. I have it also, but it's just know that it's been honored by every pope and every king ever since it's been written. And if it was not, this whole system would collapse, because the entire trust indenture fiat currency system that we have right now is entirely based on the Magna Carta, believe it or not. See, the Magna Carta is a double-edged sword. That's why I named this stream the double-edged sword, is because if you know the law, you can use it to protect your property, because it gives you the absolute right to sue out your inheritance without fee, without fine, and without fee, right? Matters of life and limb are considered gratis, right? And so there's nothing they can do. And since, like, for instance, Michigan uses the Magna Carta as their fundamental documents, the very first one right here, and they're telling you this is our source of authority. I know it's tough to see for you guys, and if I zoom in, it's probably going to take forever here. All right, Magna Carta right there, Declaration of Independence. And that's because they need the Magna Carta to give them the common law jurisdictional authority to take you out of common law and into administrative procedures, where we are now. So now, with that little bit of brief history, and everybody's caught up, I hope, right? And if not, go watch the first one to get a better idea what's going on. But we're gonna get into the founding of the United States. So when the United States, this republic was originally formed, it is formed on common law. We see that in the original acts. We can pop over. I pulled up the Virginia Bill of Rights written by Thomas Jefferson. This one. Sorry. This is their Bill of Rights, and this is probably the best Bill of Rights of any state, but it conforms entirely to common law and natural law. It says that all men are by nature equally free and independent, and have certain inherent rights, of which, when they enter into a state of society, they cannot, by any compact, meaning, contract, agreement, deprive or divest their posterity. Now, why is that important? Let me translate that, right? You have certain inherent rights endowed upon you by your creator, like it says in the Declaration of Independence, Magna Carta, this is common law. It's natural law, right? So it says that you cannot deprive your children. That's what posterity is. There, again, is that inheritance word, right? So you cannot deprive your posterity. So if I lived in Virginia and I got a traffic ticket after I told the cop that I have no contracts with the state, I'm the heir and the sole heir and executor of my estate, and that I'm not under administration. Therefore, I do not need to register the property with the state. I do not need to be told how to use the property. And then he writes me a ticket anyway. And I go to court and I say, look, this is right in the Bill of Rights. Okay. How do you have an interest in my property? Okay. So either I'm free under common law, I'm a sovereign, which is what we are. And like John Jay said, sovereigns without subjects. And I have absolute title to my estate and everything in it. all my property, or you have an interest in my estate or in my property. That means the title is split, which is what happens when you register the car. You split the title, you basically give it to the government, and then the government gets to tell you how to use it. And you got to put a slave plate on the back, which is commercial advertising, right? So the cop can link the account number to your Social Security trust and be able to generate a security for the courts to use. And that's pretty much how that works. So you take this and say, no, I don't care if my mom signed a birth certificate and you guys pledged it to the United States corporation and then they mortgaged it to a foreign banking cartel. I don't care if you did that, right? You cannot do that. It's right here in the Bill of Rights. Okay. On top of that, I'm the sole heir and executor of the estate. But let's see if you guys have any questions. So I know this is some heavy stuff. Theo Shen says, I'm taking notes. Mr. Thede says, one more time, please. Which part? You'll have to be more specific. Wonder if I can use AI to take notes, but I'm afraid we don't want AI to have this knowledge. I mean, I've thought about that, but I don't see how AI's been trained. So Michigan is not a Commonwealth state. And actually, I was going to show you guys that next. But after I read this part, Michigan's a Confederate state. Did you guys know that? All states are Confederate. How many people here know that? Yeah, pretty mind-blowing, right? You thought Confederate was like racist, right? White supremacy and all that? No. Confederation is a type of union. Okay, so we're going to get into that. But let me read this, that all power is vested in and consequently derived from the people, that magistrates are their trustees and servants and at all times amenable to them. Magistrates. Okay, so these are like justices of the peace, and that's all they did in a court. Was you were the sovereign of the court. The substantive definition of court is the sovereign in a suit, right? So you hold the court. The court derives authority from you personally. Okay. See, we're losing people. Must be a little too heavy. Listen, it's not for the faint of heart. So if you ever accepted, Dylan Heron asks, if you ever accepted benefits from the government, you can't claim your estate, Ryan? No, you need to quit accepting the benefits. Right? So you can still come of age. The entire time, just think of it as if another person has been trustee of your estate all this time, and now you've come from beyond the sea and you're reclaiming your estate. So whatever's going on before is none of your, you know what I mean? It was under administration. Okay, well, we need a full accounting to see what's going on while I haven't been here. And that's sort of what claiming your estate is. You put it on the record. I can prove it. This actually works. I proved it on the last show at the end. I'll prove it again tonight. It works. It really does. So, yeah, AI. Jace Ventura says AI will only learn how to lie better. And Chicago Cubby Bear. Yes, if you are in Chicago, you're in a state that's pretty much as bad as California. Dylan Heron says, I live in Massachusetts. Yeah, that's another very bad one. Don't they consider the U.S. dollar as a bet? Well, it's not a dollar. We don't have U.S. dollars. We have Federal Reserve notes, right? They measure the monetary units as dollars, but they're not dollars. They're just slave tickets. They're notes. We're going to get into that actually. So let me show you guys that Michigan is a Confederate state and try to make this a little bit more fast-paced because. You know, that's the thing that's tough about teaching law is that most people get very bored of it very quickly, but then they want to bitch about who the president is and how things are going in the government. And they have no idea how it even works or anything. They just are so black-pilled. I talked about this before. They're so black-pilled that they just think everything's fucked and there's no hope. And they can't actually understand like the process of revolutions are rare. Okay, like actual physical violent revolutions, and they rarely result in the birth of a new nation like this one. Okay, usually it's just a bloody revolt and then it's stamped down, and that's how historically it's always been. The true change comes through people standing up, learning the law, and working together in civil war. Well, that's not a good term. And court is warfare also. Okay, court is the warfare. Court was created so that we do not have to kill each other. And so if you learn the law, you can take these shackles off, even if the rest of the world is not ready to. And you know what? Not everybody's going to be ready at the same time to not have shackles. That's how we ended up in this situation in the first place. See, they gave us this republic, said you're free. They made us all peers, which was a class formerly. So you hear judged by a jury of your peers. Well, that class of people was formerly reserved for just the family of the king. Those are peerage. It's called peerage, like how that little girl found out all the presidents are related to the European royalty. She found out in a book called Burke's, or on a site called Burke's Peerage, a service. And that's because that's what peerage actually means. So they gave us the peerage en masse as a republic. And then because people were not ready to be free, they were poor, they were spendthrifts, they needed, they couldn't take care of themselves. So they gave the freedom right back. So you're never always, not everybody's ready for this, but because the pathway exists in this republic still, as long as this republic stands, then we have a way back. And I'm showing you the way back. Does that make sense? Yes, it was all presidents but one were related to European royalty. And so William says, what question did, well, your currency, I mean, because yes, it is a benefit to be able to use the Federal Reserve note. However, here's the caveat with that. When they have made it impossible for you to exercise your natural unalienable rights, right, without using the FRN, the Federal Reserve note, you use it under duress and without prejudice. Use it under duress and without prejudice. You use it because you have to use it because you cannot exercise your rights to life and property and the protection of your property and providing for your family and all that. You can't do that without using the Federal Reserve note because they have engineered society as such. And they used fraud, coercion, and collusion to do it. So that vitiates any agreement they think they might have. And so it's under duress. Now, back to all states being Confederate states. Check this out. This is in the appendix of the revised statutes of Michigan, 1846. May 18th, 1846 is when it was approved. And if we zoom in right here, this is at the end, they're accepting their entry into the Union, essentially. And it says, now, although, here, let's take that. Okay. Now, although this convention are of opinion that the Congress of the United States had no constitutional right to require the assent aforesaid as a primary preliminary to the admission of the said state into the Union, nevertheless, as Congress have required such assent to the said condition, and as the interest and prosperity of the state will be greatly advanced by an immediate admission into the Union instead of being a territory, as one of its sovereignties, because each state is the country, as one of its sovereignties, okay? The United States, as we know it, when you're talking about the entity and not the continental United States, the United States is a trust, and now it's a corporation, which is another form of trust after 1871, right? And the people of the said state are solicitous to give to her sister states and to the world unequivocal proof of her desire to promote the peace, the tranquility, and harmony of the Confederacy. Does everybody see that? Confederacy. All states are Confederate. It's a massive psychological operation they've done with the Civil War and taking control of history, making you think Confederacy bad, Confederacy hates black people, Confederacy racist. Let's tear down Confederate statues. You know why there's Confederate statues? Because they were the only ones actually protecting the Constitution. That's why. Because what Abraham Lincoln did was tyrannical, and he destroyed the Union. He is the reason that that foreign corporation known as the United States now territorially occupies the several states. And they overlaid a zone improvement program called zip code and Social Security. They created 10 Social Security zones. So they've overlaid several jurisdictions on top of the original republic and its federal occupation. So now let's bounce back a little bit. Now we know states are Confederate, right? And let me check for questions. I got to remember because I get ahead of myself on here. Let me make sure you guys are with me. Let's see. How long did it take to master this plan, right? So he says, how long did it take to master this plan? Hard to think they came up with this on their own. This is some massive evil system. Well, actually, like I said, the Magna Carta almost seems to have been engineered to allow this to happen. So if you really want to talk about how long, I'd say at least since 1215, personally, because the barons are now the corporate oligarchs, right? So what happened there when they wrote the Magna Carta opened the door for these barons who are not the king. You could only have one in the family be king. And remember, all the barony were family of the king. There were nobility or royal bloodlines. But they could not be king, only one king. Well, now see with this corporate oligarchy that they've created under the administrative system, right? And the fiat with the fiat currency, now they're basically all kings, co-equal kings. They're corporate gods. And that's what they wanted the whole time. They wanted to be able to be king, to have power of the king, to have power over the people, like the, you know, and that's where we're at. Rothschild's one of the names, but see, that's where I get confused, because there was a Rothschild that was a part of the drafting of the Magna Carta, but the Rothschilds as we know them today were Bowers. So I'm not really sure how. I'd have to do some more research before I really talk about that. But yeah, so Confederacy, all right? So they want to promote the tranquility, harmony of the Confederacy. So we're going to bounce back a little bit. We're going to bounce back. It says, hi, Ryan in chat. Mike says, hope everyone is doing well. Good to see you, Mike. All right, we're going to bounce back to Penhallow versus Stone's administrators. This is a 1795 case. Okay, it's a funny story about me coming across this case, and I want to warn you guys when you do research. Okay, so you'll come across like these memes and stuff, and this is how I found this case a long time ago, and I actually looked at it and didn't say that, and it said that in the meme I found, it said Penhallow versus Stone's administrators. The government cannot attain parity with the people because the government is an artificial construct of the mind and has no existence in fact. And that's what it said was in this case. Now, while that is true, 100%, that is not openly said in this case, but other very good things are. And so you got to be careful when you just blindly recite something without going, that really has bit me in my ass before a long time ago. And, you have to go read the case and make sure it's in there. If it's not in there, there's probably some other good stuff in there that would indicate whatever was just brazenly, said as if that was in there. But so what it says here, let me see if I can, whoops, wrong one. This screen over here. Sorry, guys. All right. So we zoom in and where the hell did that go? Why am I all the way down here now? You piece of shit. Hold on. They make this intentionally difficult to navigate sometimes, I swear. So let's go up. Okay, here we go. So it says, but wherever an alliance is not corporate, which it is now a corporate alliance, that's why you had the capital S first. The states are supposed to be lowercase s anyways, because the people are the sovereign. Then after the Civil War, they became capital S states. And now under this administrative system, they're all caps, right? That's the corporate system. But it says wherever an alliance is not corporate, but confederate, the sovereignty resides in each state and within the people. See, because whatever powers the people did not cede to the state, they retain for themselves. And whatever sovereignty the people vested within the state, they retain for themselves anyways. If the state can hold court, you can hold court, and it works. It absolutely works. Just go watch my videos, Superior Court of Record, The True Power of the People. And so then we go down here, and it says that now the state retained all powers which she did not expressly surrender to the Union. A state cannot cease to be sovereign without its own act, nor can sovereignty be asserted but upon a clear title. So that means if you're in debt or if you do not have absolute claim to your title, remember your title has to be clear. There's the word title again. Title to what? Title to your estate. Okay. If you do not have absolute claim to your title, then you do not, somebody else has your will. You do not have free will. Somebody else has your volition. Somebody else has, you're a slave. You're indentured. That's just is what it is. Right. So, that's very powerful. Two very, very, very powerful citations from this case. Absolutely. Now, so what happened? All right. Well, we know it's the war against the central banking cartel, in essence. Okay. Let me shut this down for a second. We'll pop back over there. But essentially, the story of this country is the story of a war against the central banking cartel, the money powers. So, funny thing, like the fire going on in California right now, is much the same as the fire Emperor Nero set back in 440 whatever BC. when he wanted to expand his powers. And when you pull up the 12 tables, actually, why don't I do that? Pull up the 12 tables. It's going to be the same thing, guys. Guess what? This is the basis of law. I don't care if you like it, don't like it. It is what it is. I'm going to pull this up for you. This is the 12 tables from the 440 something, 449 BC. Sorry, guys. A lot of dates to remember. Whoops. We need to pull up. Hold on, I got to cancel it and then bring it back up. Window. Right there. All right. So 449 BC, right after he burns down Rome with the consent of Senate, and he did this to expand his power. It was to basically kill or burn out the illiterate peasants and be able to take control of their estates. See, when Rome was a fledgling country and when the court system started up and everything like that, they were very uncertain about even trying to make people go to court. They didn't enforce judgments. The plaintiff had to enforce the judgment. You know, they were unsure about trying to get the people to go along with the bullshit that they were trying to do as a government and as a court, because people were free. That's the whole thing. A mankind in a state of nature is free, right? So it says that man in a state of nature is free and independent of all institutions of his fellow men, absent consent. And that is Crude versus Neal, I believe. Yeah, it is, because that was about the Revolutionary War. And so right here, after he burned down Rome, it says, here's the word, administration of his own goods shall be forbidden to a spendthrift. A spendthrift who is forbidden from administering his own goods shall be under guardianship of male agnates. If a Roman citizen freeman dies intestate without a direct heir, to his patron shall fall the inheritance, said household into said household, meaning that's called reversion under common law, right? So when a person makes bond and conveyance according to as he specified with his tongue, so shall be the law. That's a contract, right? It's the same going all the way back then. So what happened in this country? The same way that they used the London fires going on is the same way that they were able to create the Set the KV Act, or I'm sorry, the California fires going on is the same way they were able to create the Set the KV Act in 1666. So Nero burned his stuff to the ground. Many other leaders have done it all throughout history. The one you need to be concerned about is King Charles II, right? So King Charles II burned London to the ground right after there was a plague. Well, I'm sorry, London magically burned to the ground on its own, I guess, or whatever. Or somebody was, a cow. I don't even remember what the excuse was, but people said they've seen people starting fires. 70,000 people died, and then he passes this act right afterwards in 1666. And it says, whereas diverse lords and manors and others have granted estates by lease. See, this is all the way from 449, all the way up to 1666, all the way up to right now. It's all the same stuff. Whereas diverse lords of manors and others would have granted estates by lease for one or more life or lives, or else for years determined, blah, 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 right? And it's basically saying have been granted and have gone beyond the seas or so absented themselves for many years that the lessors, meaning the renter, the person who owns the property or who has the title to it, and the other person has the title of use, basically the legal title or the equitable title to use the property, has been gone because you just burned them all down and whatnot, right? Revisioners cannot find out whether such persons or persons be alive or dead, by reason whereof such lessors and revisioners have been held out of possession of their tenements for many years after all the lives upon which such estates depend are dead, in regard that the lessors and revisioners. So basically what he's saying is, we don't know that if you're alive or dead, and we need to do something with this property because the people who own the property ultimately cannot make any money off of it, because you're still a tenant and we can't just do anything when it's supposed to be yours, et cetera, et cetera. So this was a way to create a presumption. And now they're saying if you don't come forward, they created the court of wards after this. And basically what this says is you have to go prove your life. You have to sue out your livery in the court of wards, right? here it is. If such person or person for whose life or lives such estates have been or shall be granted aforesaid shall remain beyond the seas or elsewhere, absent themselves in this realm by the space of 7 years together, and no sufficient and evident proof be made of the lives of such person. They're using this today, guys. Such person or persons, respectively, in any action commenced for the recovery of such tenements by the lessors or revisioners. In every such case, the person or person upon whose life or lives such estate depended shall be accounted as naturally dead. And in every action, that's a common law term. That means that you have to do an action at common law, which is what a declaration and of claim of title is, which is what I'm doing, what has been done, has worked. In every action brought for the recovery of the said tenements by the lessors or revisioners, their heirs or assigns, the judges before whom such action shall be brought shall direct the jury to give their verdict as if the person so remaining beyond the sea or otherwise absenting himself were dead. So that's how they take the property under presumption, right? And then you have to have an action at law to bring it back. So right here. So here it is. It says, I don't want to read all the boring stuff because I'll lose you guys, but I'm trying to get to the point of it. It says, let's just start here. Tenant or lessee who has outed of the same, his or their executors, administrators, or assignees. There's those trust terms again, right, guys? Executors, administrators, or assignees shall or may re-enter, repossess, have, hold, and enjoy said lands or tenements in his or her former estate and for during the life or lives or so long term as the said person or persons upon whose life or lives the said estate or estates depend shall be living, and also upon action or actions to be brought by him or them against the lesser revisioners, which is the people who own the property, right, or tenants in possession or other persons respectively. Okay, so this created the Magna Carta created the ability they created the ecclesiastical court to be able to administer the estates of minors. And then this act, this isn't the first set the KV Act, but this is the most important one and the last one, created the ability for that ecclesiastical court to presume you dead if you have not come forth with an action to prove that you were living. Now all that remained was for them to be able to presume you were dead as soon as you were born, and for you to not know that you need to come claim your estate within 7 years. And that's what they ended up doing. But it took them some time. And so the story of this country is this, and the reason they did this, that's why I brought this up in the first place. The reason they did this at the KV Act, so they burned London to the ground, killed 70,000 people, right after a plague that killed a bunch of people. So massive amounts of death in England. And then he took all of their estates under administration, right? He took power of attorney essentially over all the states, which is exactly what it is, over all the estates of all the subjects in the realm. And he used that as collateral to start what, guys? Guess what? The Bank of fucking England. Same wash, rinse, repeat shit that they did for the Federal Reserve in this country after the Civil War, after, 1913. And so now we're going to start getting into this stuff. So what is originally in our original republic, DC had nothing to do with you. So people all the time want to bitch about who the president is and all that stuff and the way government goes and they're all actors and they're all puppets and blah, blah, blah. You're the government, dude. You're the power. It's your lazy ass not learning the law that causes the problem. You can't even have a conversation about this stuff until you. So do you guys know how how you voted for the president under the original republic? Anybody got anything? Put it in the chat. People watching this playback, just think about it for a second. Do you guys know how you elected the president, the president of the United States under our original? You did not. Because, hey, RF is killing us softly. Good to see you, man. You did not vote for the president. No, because Congress and the president, nothing in the federal government had shit to do with you. They had no jurisdiction over you. You were not even in existence to them. They couldn't even be in the same realm as you. There's actually a court case that I can show you guys. Let's see if I can pull it up real quick. It's called, if it's not my favorites, I'll be able to pull it up, but it should be. Yep, it's right here. So check this out. Actually, we're going to open it over here because I would have got rid of my set to KV. And this proves it. This is from 1922. Okay, so before they did the bankruptcy and before they mortgaged your estates and everything and then forced everybody to become United States citizens through FDR's New Deal welfare programs, you adopted a social security number. Now you're a federal personnel on deferred retirement benefits paying into a trust account that they use as the very foundation for all the securities they generate from your slave ass. But here, let's check this out. So this is Long v. Rasmussen, right? So basically what happened was this IRS agent tried to distrain this lady, Edna Long, of her property for tax debt, essentially, right? And it wasn't even her tax debt. But she took him personally, because she wasn't going to take the IRS itself to court, but she took him personally to court. And listen to what the judge says about it. It says, and you guys are going to like this, because this is proving exactly what I'm trying to tell you. The revenue laws are a code or system in regulation of tax assessment and collection. They relate to taxpayers, right? As in those who are abandoned, are infant estates that they can reach in and take directly out of or claim that you owe a tax on your wages, which is your private property, because you're under administration. So you're not using your property, you're using the estate of another that's presumed to be dead, and it's under the administration of the government, the courts. So you're using that property, you're charged a fee for using that property, and that fee is income tax. And so when they say taxpayer, they're talking about 14th Amendment citizens and not to the non-taxpayers. The latter are without their scope. No procedure is prescribed for non-taxpayers, and no attempt is made to annul any of their rights and remedies in the due course of law. With them, Congress does not assume to deal, and they are neither of the subject nor of the object of revenue laws. So see how they don't openly say state citizen, federal citizen, they say non-taxpayer, taxpayer, right? And that's how the bar pirate tries to kind of hide what's going on here, but they had no lawful jurisdiction to distrain this lady of her property because she was not a federal 14th Amendment citizen. You might be saying, oh, well, Ryan, what do you mean 14th Amendment citizen? Well, I'll tell you, but let me check Godheart Guardian. I appreciate the compliment. Yeah, 33 in the chat. Illuminati confirmed. Shit, they're on to me. But yeah, so that proves that. And so you say the 14th Amendment. What is the 14th Amendment? Well, I'll show you. The federal government was never supposed to have any citizenry. Okay, so this is, why did that not switch over? Why are you not switching over? Can you guys hear me? Let me stop that. Whoops. Are you guys still with me? Okay. Not really sure why that didn't switch back over, but boundary stones. This is how DC was originally laid out. This is the only place where the United States has jurisdiction. Don't believe me? I'll show you. On this side of the boundary stone, it says jurisdiction of the United States. And on this side of the boundary stone, it says Maryland. Okay, because the United States is not a nation. It's a federal corporation, and it was caged in by boundary stones to the 10 square miles of the District of Columbia right here. Okay, it is not, there is no such thing as a federal citizen. We'll pop back over to Black's Law. Oh, I'm sorry, that's Blackstone. Did I bring Black's Law over? No, I didn't. Here, I will right now. That's right. I'll just put it there. Okay, now it's going to make me stop the screen and represent it again. Sorry, guys. Need to get a little bit more fluent. Okay. So, Black's Law. Okay, this is 4th edition. Yes, 4th edition. So we look at the definition of, there it is, 14th Amendment. And we're going to zoom in super tight on this for you guys. And we're going to go over here, and it's going to say the 14th Amendment of the Constitution of the United States. It became part of the organic law July 28, 1868, and its importance entitles it to special mention. It creates, or at least recognizes for the first time, a citizen of the United States as distinct from that of the states. Okay? It created the federal citizenship. Why did they need the federal citizenship? For collateral, for borrowing from the central banking cartel. So now watch this trust video, or watch this guy beat this case. Now keep in mind the terms administrator, executor, trust, stuff like that. Those are all trust terms. Anytime you hear the term administrator or administrative, it is a trust term only, ever, always in law. Now watch this with new eyes and tell me what you guys pick out in the chat.
No.
All right, sit down, please, sir.
Just key.
All right, just wait.
Key. I'm here to correct a mistake by the court.
Well, first of all,
If the court has made a mistake,
are you Wilfred Keith Thompson?
no, that's not what I normally go by, no.
Can I see the information?
That's a fictitious affidavit in terms of person legally speaking, so. I've tried to clarify this a few times, but apparently the level of incompetence.
So your name is Keith Thompson?
My name is Keith, that's all, nothing more, nothing less.
You don't have a last name, sir?
I have a family name, clan name, but that's irrelevant today.
So you are not Wilfred Keith Thompson?
Okay, one more time, on and for the record, I am Keith, nothing more.
And sit down, sir. I'm looking for a Wilfred Keith Thompson. Please sit down, sir.
Actually,
Please sit down, sir.
Sorry. Can't do that. I served into the court this morning.
Sir, I'm looking for a Wilfred Keith Thompson. You are not that
This is a
person. Sit down, sir.
bailiff.
Please remove this gentleman from the courtroom.
Thank you. That's the person you're looking for.
Please,
Sir, that is the person. I'm trying to remedy things. Touch me and you will be charged. I'm a peace officer. You want to dishonor a court official?
The defendant's on the bailiff's desk.
sir, are you here on behalf of Mr. Thompson?
I said I was the administrator to that account.
Are you here as agent for
Could you
him?
guys please back up? Thanks.
Are you here as agent for him?
Not as agent, as administrator, much like you are administrator of this court.
Sir, you're either him or you're here as his agent to speak on his behalf. Are you either of those?
Yes, it's lawful.
Pardon?
Yeah, he's
So right there, how he says, I'm the administrator, much like you are. That's a no-no, because the administrator is one not appointed by will. You want to be the executor. But this is how he gets the judge to pop up. He gets him so pissed off because he won't give him jurisdiction. There cannot be an executor and an administrator. Or, I mean, I guess this is not exactly right, but there cannot be two administrators simultaneously. There's only one administrator or there's an executor. There cannot be an executor and an administrator, and there cannot be two administrators. So check this out.
He's in common law jurisdiction, which I established as soon as I came in here this morning and reestablished again. The bailiff understood me. This other bailiff, wherever she went, she understood me as well. And this gentleman doesn't like talking.
We're going to take a recess. Thank you.
Thank you, all rise.
How long?
How long, sir? I don't have all day, thank you. I have things to do.
We'll take the court.
Yeah, actually,
This court will recess.
please note that the judge has abandoned the court. It's abandoned ship, and I.
He should have already done that before this clerk over here said, we'll take the court, right?
The sovereign in this room, claim authority.
And notice their black robes. This is the ecclesiastical jurisdiction of William the Conqueror I was talking about.
Case dismissed with cause and prejudice.
He is the sovereign of the court right now. So that should look a little differently to you guys now after I gave you guys that yes, the magistrate did bow, Chris. Absolutely. So why did they need to create federal citizenship? Now that you guys watch that again, you understand it a little better. Because while the states were already busy sheeting the estates of their citizenry through presumption of spendthrift or distracted person is one of the ones in Michigan's probate code. Distracted person, spendthrift, lunatic, infant, of course, right? Minor, infant. There's several other ones. They're just ridiculous, though. Just like for almost any reason, they needed to centralize the borrowing power because everything about the battle that we're in is against the central banking system. And so the central banking system first tried to get its claws in, and I think it was 1781. Well, even before we were a country, there's First Bank of North America. Then Robert Morris, who had actually been charged for war profiteering a couple years prior to being allowed to start the first Bank of the United States in 1791. The bank was given a 20-year charter. Okay, charter expired in 1811, and Congress refused to renew the charter because there'd been so much. They were, inflating the currency and doing all the bullshit that central banks do. And so Congress said, "No, you know what? We'll take it from here." And so Nathan Rothschild got pissed off, and he said, "Hey, you tell those colonists that if they don't renew or you tell the Americans if they don't renew the charter, we'll take them back to colonial status." And we still said no. And so Nathan Rothschild said, "Okay, take those impudent Americans back to colonial status," right? So boom, sends over an armada. Canada attacks us because that's been a crown colony for a long time. And Canada actually kicks our ass pretty good. But we, I guess we win, but we also renew the charter for the central bank. Well, Andrew Jackson was an officer in the War of 1812. And he had been captured as a POW by the British, and he had been abused. And he also lost most of his family during the war due to like typhus disease, starvation, all sorts of stuff, right? And so he hated the banks and he hated the British. And so once he came of age and established his political career, he ran for president. And who here knows what Jackson ran on, what Jackson's platform was for his presidency? So vote for the man who'll kill the banks, right? Vote for the man who'll kill the bank. Yes, Dylan, Canada did kick our ass. It is embarrassing. No offense, Canadian subscribers, but anyway, yeah, so he said, vote for the man who will kill the bank. And so he was the first presidential candidate to actually take his candidacy on the road and actually go speak to the people. Of course, the people did not directly vote for Jackson because that wasn't a thing. Like I told you guys, it's not how we elected the president, but they elected an elector, and the elector, the county electors, voted for the president. They also voted for other offices as well. Okay, because the entirety of government, both state and federal, were beneath us. And to elect, you had to be part of a voting trust, and therefore you had to be subject to the government. So we elected an elector, right? And talking about the federal government for that voting trust, it's called elective franchise. So you had to be a landowner also to elect the elector in the first place. So Andrew Jackson gets elected. And he removes in his first term most of the bank's agents. I mean, there was thousands of banker employees within the government, banker agents within the government. He spends his first presidential term routing them out. And then his second presidential term, he actually finishes getting rid of the bank. He kicked the bank in the nuts, and it took him over 70 years to recover from that ass kicking because they didn't come back till 1913. And when he was on his deathbed and he was asked what his life's greatest accomplishment was, he said, "I killed the bank." So that's like, this is Andrew Jackson's legacy. I think that's also why they put him on one of the most circulated bills, is like kind of like thumbing their nose at him. So fast forward. Now it's very hard for a central bank to get its claws into the country anyways, because each state is independent, sovereign in the Confederacy, right? Because remember, northern states, all states are Confederate. And so the sovereignty resides within the state. And in order to get their central bank scheme going to where they bankrupt and then can enslave the population through debt, they need control over the people, the citizenry. So that's why the federal government was created to begin with. Shays' Rebellion was a false flag. The Whiskey Rebellion that George Washington had to go use his own personal troops to stamp out or whatever. False flag to justify the creation of the Constitution, the drafting of the Constitution. And their excuse was, Washington had to use his personal troops because the same, and I believe it was Patrick Henry actually brought this up in opposition to the Constitution. He says, you're gonna accuse the same government who saw us through a war against the most powerful nation on earth. You're gonna accuse it of, what do you say, like abandonment or something, lethargy, like it's not capable of doing this. And it saw us through the war against the most powerful government in the world at the time, which was England. And so anyways, they got the Constitution ratified without the consent of the people. People weren't allowed to know what was being discussed. And it was behind closed doors without armed sentries outside the Constitutional Convention. And The Constitution is a subversive document that created the judicial branch, which ultimately usurped the power of the states and thereby the people for the banks, because the bar and the banks work together. So back to Jackson. Jackson got rid of the banks, right? And they needed, that's the Constitution was created for a strong central government in order to centralize the borrowing power. Now, the only thing that central government was missing was collateral, okay, because it didn't have citizenry of its own. And we'll pop back to Black's Law, 4th edition, just in case you're just now joining us, so we can actually see that. The 14th Amendment created or at least recognizes here. It creates or at least recognizes for the first time a citizenship of the United States. Okay, so what Lincoln did was entirely unconstitutional. He's a tyrant piece of shit. Okay, he's the worst president. Well, FDR is the worst president, but Lincoln's the worst president only because FDR was only able to do what he could do because of Lincoln. So you talk about executive order. Do you guys know what the first executive order was? It was General War Order Number 1 by Lincoln, declaring war against the South. That was the very first executive order. That's not a power the president has. He took that upon himself. So nowhere in the Constitution does it say anything about an executive order, right? So, and now the executive order has been used for a long, long time to fuck us over. And so now, you know, I'm of the opinion, I'm at least glad that there's somebody in there that will use the executive authority properly to undo some of this shit. But at the end of the day, the only people who are going to fix this is you by reclaiming your estate. Just like I'm telling you, because this is our country. It's not the government's country. The government is a utility. It's a tool. It's vested with our sovereignty. It's actually now just taken our sovereignty and placed us as infants under administration. And only you can fix that. All right. So back to the 14th Amendment. Here's another interesting thing about the 14th Amendment. And I actually had somebody message me and tell me that Clarence Thomas said that we all need to take a closer look at the 14th Amendment because it creates dual citizenship in the very first sentence. So we're going to go here and we're just going to go 14th Amendment, right? And we'll pull it up for why not? Cornell's fine. Section 1, all persons born or naturalized in the United States. Okay, talking about the geographic several states here, but then says, and subject to the jurisdiction thereof, now it's talking about the corporation, are citizens of the United States and of the state wherein they reside. So, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That would be redundant if that was already the case, which it was not. I can prove it 20,000 times over. We've got, what do we got over here? We got McDonald v. State. I'm pretty sure I have right here. McDonald v. State. Boom. Indiana Supreme Court. Gotta love it. You guys still with me? This guy charged with murder, jury convicted him. He appealed, said one of the jurors was an alien, saying that he wasn't a federal citizen. He was only a state citizen. And so it says, the evidence of bushing on his voir dire showed that although he was a citizen of the although he was not a citizen of the United States, he was a citizen and voter of the state under Section 2 of Article 2 of our state constitution. One may be a citizen of the state, yet not a citizen of the United States. Oh shit, you guys aren't even able to see this. That's no bueno. Here, let's share the window, shall we? We don't have to keep dealing with this. There. See this? The evidence of bushing on his voir dire showed that although he was not a citizen of the United States, he was a citizen and voter of the state under Section 2 of Article 2 of our state constitution. One may be a citizen of a state and yet not a citizen of the United States because that federal citizenship was created by the 14th Amendment. This is from 1883. Okay? The 14th Amendment's from 1868. So this was a whole new thing with the federal citizenship. And even Andrew Johnson's veto message he says that it's the federal government cannot take from the states the right to bestow citizenship. That's just they needed to create their own citizenship for collateral for the banks. And I'll prove this because I bring, as Dylan Heron likes to say, I bring the receipts and I have them for you. So we'll pop back over to the 14th Amendment real quick, just by hitting back, I suppose. And we go down. So this is sold as an equal protection amendment. What really happens is basically they're saying the government will they said that they were going to grant rights to the newly freed slaves since they did not have any rights under the Constitution, which, as Andrew Johnson, the then president, aptly pointed out, that all they had to do was learn how to be sovereign. They, in time, learning how to, be civil, operate in society, live civilized, they would be able to start their houses, having in their state and be sovereign. Andrew Johnson said that as part of his veto message as well. So, and actually, I think it's in the congressional record I have over here that I'm going to show you in a moment. But this is interesting. So they sell it as an equal protection amendment, and they don't even lawfully ratify it, which we're about to see. And they say we're going to grant these rights to these newly freed slaves because they don't have any under the Constitution, right? Because they're newly freed slaves. When really they're not rights, they're privileges, because God endows rights. Government grants privileges. So all they did was create public chattel. They took private chattel and made it public chattel. That's also where so when we bring up Clarence Thomas says we need to take a closer look at the 14th Amendment. And the detractors are like, oh, well, you don't want to do that. It's a Supreme Court justice, for those of you who do not know that. You should know that. But, and this was just recently in response to trying to use the 14th Amendment to not certify Trump. It says we all need to take a closer look at the 14th Amendment. They're like, well, you're in a mixed race marriage. You're married to a white woman. Well, here's the thing. The reason that this created the marriage license in the first place, you had to get a license to marry the government's chattel. It has nothing to do with them being black or anything else. They were now public property. They were now state or federal chattel. See, because by taking these people in under administration, that's what they did. Basically, the newly freed slaves and anybody who signed up with any kind of contract with the federal government to be a federal citizen gave over title to their estate in exchange for privileges, which they already had as rights if they were not a slave prior. They already had those rights, but now they only have privileges. And now, because you've given over the absolute title to your state in exchange for what amounts to protection, you're now under administration by the federal government, and they can do with your estate as they please. Do you guys get what I'm saying? So thank you, Winbay Bear. I appreciate it. It said, DQR64 says, an elector was told to go and vote for president. That's absolutely right. Yes. Well, he was elected to go and elect the president. So he elected the way that his electorate voted for him to elect. And that's how that worked. And at the end of the day, it had no direct impact on the people direct impact, because Congress nor the president has anything to do with you. Right. So now this is what I find interesting. If this was an equal protection rule, or equal protection law, then why does Section 4 start out with, this is an equal protection law and not expanding their collateral to borrow against, using it as security for the central bank. Then why does Section 4 start out with the validity of the public debt of the United States authorized by law, including debts incurred for payments of pensions and bounties for services and suppressing insurrection and rebellion, which is under which police exists, shall not be questioned. So let's cut out the middle stuff. The validity of the public debt of the United States shall not be questioned. Can you fucking imagine what you do with my money? I can't question you. Are you kidding me? You're not even supposed to be taking my money. The only money you should have is through the proper tax system, period. Sales tax, import tax, export tax, certain excise taxes. No such thing as fucking, but even that, you're telling me I can't question it if I'm a federal citizen. Why the fuck would I ever want to be a federal citizen? Why in anybody's right mind would they ever want to be a federal citizen? And as we just seen in McDonald v. State, one may be a citizen right here. One may be a citizen of a state and yet not a citizen of the United States. Two different citizenships. and you don't want the federal one. So now we're going to go to not 1933 yet. We want 1967. So bear with me, guys. Where you at? It's probably over here. Here it is. Okay. So we'll just put it right there. Okay. So this is June 13th, 1967, House Congressional Record. Guess from where? Congress.gov, because that's where I get my shit. And this entire thing is about the 14th Amendment. And what does it say? The 14th Amendment, equal protection law or tool of usurpation. See, this is why I wanted them to bring up the 14th Amendment when they were talking about not certifying Trump. I wanted them to bring up the 14th Amendment because it was never lawfully ratified. And I'm like, shit, yeah, go ahead and try to bring that up because we do need it. This is what Clarence Thomas is talking about. So the 14th Amendment is unconstitutional. It says the purported 14th Amendment to be the United States, right over here, to the United States Constitution is and should be held to be ineffective, invalid, null, and void, and unconstitutional for the following reasons. The joint resolution proposing said amendment was not submitted to or adopted by a constitutional Congress, right? Article 1, Section 3, and Article 5 of the U.S. Constitution. That's what it violates. The joint resolution was not submitted to the president for his approval. Article 1, Section 7. The proposed 14th Amendment was rejected by more than 1/4 of all the states. Almost half of the states rejected it. Okay, so the unconstitutional Congress. It says the fact that 23 senators had been unlawfully excluded from the U.S. Senate in order to secure a 2/3 vote for adoption of the joint resolution proposing the 14th Amendment is shown by resolutions of protest adopted by the following state legislatures. New Jersey, right, by resolution said the said proposed amendment not having yet received the assent of 3/4 of the states, which is necessary to make it valid, the natural and constitutional right of the state to withdraw its assent is undeniable. Now that's a northern state. That's New Jersey. Everybody was against this because of what it's federal territorial occupation. Like the Union states were like, oh shit. Well, Michigan was probably happy about it, fucking scumbags. But a lot of the northern states were like, oh shit. And the United States Corporation was like, gotcha, bitch. Yeah, you just destroyed the Confederacy. Yeah, you just destroyed state sovereignty. Good fucking job. Yep, now we're coming up in there. Okay. You're going to adopt the Constitution we tell you to. You're going to mirror the United States Code. Well, it was revised statutes of the United States. Our statutes will be your statutes, right? So here, right here, proposed amendment, there's only a couple. I mean, this thing's so filled with just gems, right? Just gems that you can use in court or against any stupid fucking lawyer that tries to tell you you're a conspiracy theorist, dude. You can so many gems. I brought this to a lawyer. I brought this and much more and had a conversation with the lawyer. And at the end of the conversation, he says, okay, yeah, you know exactly what you're talking about. Yep. You know exactly what you're talking about. And then he said, you're going to want to file that into a motion because if you go in there on this, this was a while back. He says, if you're going to want to file that into a motion to force the judge to hear it, because if you go in there doing that now, she's just going to toss you in jail. But if you file this in a motion, now I know better. I won't even play in their court. I'll just take my estate back. That's it. I'm the sole heir and executor of the estate. Fuck off. I'm not playing in your courts of equity or administrative hearings. You can get out of here with that shit. So anyways, proposed amendment never ratified by 3/4 of the states. So it says, pretermitting the ineffectiveness of said resolution as above, 15 states out of the then 37 states of the Union rejected the proposed 14th Amendment. So it says Texas rejected it, Georgia, Florida, Alabama, North Carolina, South Carolina. So that was a Union state, North Carolina, Kentucky, Kentucky right here, right, guys? All rejected the 14th Amendment. Virginia, Louisiana, Delaware, Maryland, Mississippi, Ohio, another northern state, right? New Jersey, another northern state, right? So, and his Andrew Johnson's veto message of March 2nd, 18. So even Andrew Johnson vetoed the 14th Amendment, said, no, bitch. And they still just went ahead and acted. They said, it's ratified. That's all they did was just said, well, it's ratified anyway. It's not. So now we can use this is in congressional record. We can use this in court. You can use this in your paperwork. Be like, dude, I'm not a United States citizen because no fucking such thing exists. The 14th Amendment was never lawfully ratified. Not sure, but it doesn't list Oregon in here. So anyways, he says, Andrew Johnson says, it is not denied that the states in question have each of them an actual government with all powers, executive, judicial, and legislative, which properly belong to a free state. They are organized like other states of the Union, and like them, they make, administer, and execute laws which concern their domestic affairs. There's that word administer because the governments are a trust originally. I mean, corporation is still a form of a trust, but that's a whole other episode. If further proof were needed that these states were operated under legally constituted governments as member states in the Union, the ratification of the 13th Amendment by December 8, 1865 undoubtedly supplies this official proof. So what they did was they allowed all those states to ratify the 13th Amendment because everybody's against slavery. But then when they rejected the 14th Amendment, they excluded them from the ratification process and said, oh, you're not, you guys aren't states. You're not actually constitutionally, or you're an open rebellion, like bullshit, right? So we're going to go down here. I'm not going to spend too much time on this. It's dry reading, but you guys can look this up on congress.gov. It is June 13th, 1967. Okay, page 15, 641. Yeah, 15, 641 onward. Okay, page 15. And we're going to go down here and read the most pertinent points of Andrew Johnson's veto message. If ever the American citizen should be left to the free exercise, because this will place everyone who becomes an American or a 14th Amendment citizen under the jurisdiction of Congress, the legislation of Congress. And that's his biggest problem with it. It says, if ever the American citizen should be left to the free exercise of his own judgment. Oh, and also the states have to write their constitutions and their revised statutes to conform to the federal governments. And that was another big problem. So if ever the American citizen should be left to the free exercise of his own judgment, it is when he is engaged in the work of forming the fundamental law under which he is to live. That work is his work, and it cannot properly be taken out of his hands. All this legislation proceeds upon the contrary assumption that the people of each of these states shall have no constitution except such as may arbitrarily be dictated by Congress and formed under the restraint of military rule, because martial law has never been lifted, by the way. We're still under the Lieber Code. In all these states, up here, in all these states, there are existing constitutions framed in the accustomed way by the people. Congress, however, declares that these constitutions are not loyal and republican and requires the people to form them anew. What then, in the opinion of Congress, is necessary to make the Constitution of a state loyal and republican? The original act answers the question. It is universal black suffrage, to not use the other word on YouTube. A question which the federal constitution leaves exclusively to the states themselves. 10th Amendment, right? All of this legislative machinery of martial law, military coercion, and political disenfranchisement is avowedly for that purpose and none other. The existing constitutions of the 10 states conform to the acknowledged standards of loyalty and republicanism. Indeed, if there are degrees of republican forms of government, their constitutions are more republican now than when these states, 4 of which were members of the original 13, first became members of the Union. That's powerful. If you guys are still with me, that's fucking powerful. And now, so why make... Like I said, why make the 14th Amendment? This was the linchpin in their entire plan for the Federal Reserve, for the central banking system. They could never get it to quite go the way they wanted to because they were not able to expand their net of collateral to include the people within the several states. The federal government was the one who dealt with the prior central banks, like the First Bank of the United States. And the federal government had no jurisdiction over the people within the states. Now the federal government is able to expand its territory and its net of collateral to include the people within the states if they can get them to contract into federal citizenship. And so thus began the territorial occupation by the federal government within the states. I'll show you guys something interesting, right? So just a little side note, and then we're going to move on to some really powerful knowledge here, if you guys can just bear with me. But I want to show you about the resident defined by Michigan compiled laws, which is the mixture of all jurisdictions with the Magna Carta as its base. But resident means every person who resides in this state and establishes that he or she is legally present in the United States. That's weird. So you got to reside in this state, but establish a legal presence in the United States. That means you have to contract into the territorial occupation of your state. So you're in this state as a resident because you're a foreigner if you're a 14th Amendment citizen. So to be legally present in the United States, because you cannot be physically present in the United States. The United States is a state. It's a concept. It's a corporation. You're a federal personnel if you establish legal presence in the United States. So then you become a resident because you're a foreign to your own state and you are claiming nativity to the District of Columbia under the Organic Act. So just a little side note I thought I would show you. Don't you think it's interesting that it says he or she is legally present? How do you establish anything legally? Contract. That's it. It's a driver's license, right? Social Security card. Credit cards, all that stuff, legally present in the United States. That's the 14th Amendment citizen. And listen, the states were all in on selling you out. Don't feel bad for them, because with the Buck Act, they get a piece of the action. Now they get to collect state income tax and revenue off the 14th Amendment tax chattel, right? They get to collect all the revenue from the motor vehicle code, where they get to tell you how to use your property and wear your seatbelt, little infant. Don't drive too fast, little infant. Right? Make sure you put your slave tag on the back of your car, little infant, because it's not your property, it's ours. And you only have the legal right to use it. But you're going to use it the way that we tell you to use it. Or we're going to fine, fee, and incarcerate you, which are all benefits, by the way. It's philanthropic because we're teaching the infant. Fucking ridiculous, right? So now, why did they want people to contract into United States citizenship? As we've seen with Long v. Rasmussen, not everybody was contracted into federal citizenship. She was a non-taxpayer. And with her, Congress did not assume to deal. And she was of neither the subject nor of the object of revenue laws because she was a state citizen. Okay, but you'll notice this is 1922. So what happened in 1933? Right? The big bankruptcy, the big reconstruction of the government, what they call it, the Reorganization Act of the government, right? And so, well, that was technically 31, but in that era. And so I'm going to show you guys something crazy. So this is House Congressional Record, March 9th, 1933, page 83, second paragraph on the left-hand side. And this is when they're trying to decide how to keep the government going. Right. So basically, FDR issued the Gold Confiscation Act. He stole everybody's gold, or he was going to shortly after this, stole everybody's gold to pay back the Federal Reserve at gunpoint with threat of jail, 10 years in prison, basically, and $10,000 fine. Syphilitic fucking crippled bastard, piece of shit. Introduced all these socialist New Deal programs after this and stuff. But originally, so they're broke. So they have no collateral, nothing else left to borrow against of their own, but they want to continue the function of government going. And one of the reasons, just a little side note, this is the reason why they wanted a central bank to be their creditor, not the people. Because when the people are the creditor of the states and the federal government, then the people are the boss, right? And if they don't do what the people say, the people will stop paying them. But when you have a private third-party central banking cartel willing to fucking prop you up and give you whatever money you need, then it allows the government to turn around and enslave the people for the central bank. And they don't have to worry what you think or whether you're going to pay your taxes, because they're going to make sure you do, because they're not getting their money from you anyway. They're getting it from the third-party central bank. Okay. So resident, yes, the ident is actually, yeah, that is important. Indenture, ident, identity, legal identity, yeah, all that. That's definitely a thing. But so now they're trying to figure out how to collateralize the only resource they have left and use that to continue funding government. And this is where the Federal Reserve note was born. Prior to this, the Federal Reserve was issuing gold and silver certificates. And the gold and silver certificates were not inflatable necessarily, because no matter what, when you took a certificate as evidence of ownership, not evidence of debt. So when you took that certificate to a Federal Reserve branch or agency, you got whatever was on that ticket. If it said $5 in silver, you got which dollar is a measurement of Spanish silver. So when you call these Federal Reserve notes dollars, that's so inaccurate. It's disgusting. It's not even money. It's just debt contracts with two people have signed it, the Secretary of Treasury and the Treasurer, representing two parties to a contract. But when you took this $5 silver certificate to the bank, you could redeem it for $5, which was 5 ounces of silver. Okay, no matter what. Now, after this bankruptcy and after the Great Depression, all that stuff I'm going to show you, and after the Federal Reserve note came out and they basically made gold illegal, gold ownership illegal, and now it's still severely restricted. They issued Federal Reserve notes, and they're not redeemable for anything, making the public essentially insolvent. And then shortly thereafter, Nixon took us off the gold standard, started backing the currency with oil, and that made us internationally insolvent. And quite a few fucking countries threw a stink about this, and that's why the Bretton Woods Agreement ultimately failed, but it still went through. It was just piecemealed out. And that's why the OPEC's so important. That's why people are like, oh, Saudi Arabia is dropping the dollar, and people have to realize how important a move like that is, or how important a move like opening up our own Keystone pipeline is right now, because the dollar backs oil, or the oil backs the dollar international, which is not the dollar. The oil backs the Federal Reserve note internationally. Okay. But what backed it domestically? All the way from the beginning, the very thing that creates the value of the contract, that is the Federal Reserve note, is your sweat equity, and more specifically, the mortgage of your estate. Boom, full circle back to the Magna Carta. So they were able to escheat your estate under presumptions of death and infancy. And also, just to let you know, if you're a bankrupt, you're considered civiliter mortis, which is civilly dead. So it's another reason why they presume the United States infant to also be a dead person, right? You're non-living. They summons you. You're in a dead court. You're in an estate. And the estate is non-living. And then they basically they're just dealing with a piece of property from the estate that they're trying to collateralize to generate their own securities, just like the Federal Reserve note, in the form of bonds and coupons and tickets that they sell to private investors. It's a big human trafficking scheme, 100%. And I've proven this repeatedly on this channel. It's not the point of tonight's, but I'm going to show you right here, concrete, that they've mortgaged your estate. It says, under the new law, okay, money only on the left side. When I'm highlighting it, it goes all the way across. It's just the GPO, government printing office shit online. Under the new law, the money is issued to the banks in return for government obligations, bills of which are bonds, bills of exchange, draft notes, trade acceptances, and bankers' acceptances. The money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all homes and other property of all the people in the nation. They mortgaged all the 14th Amendment citizens' estates. So they waited till they got the majority of people into 14th Amendment citizenship. Then they've crashed the stock market, sent everything into a depression, created bread lines a mile long. And then the remainder of people who were not United States citizens either died off or had to sign the contract to survive and get benefits from the government to get them through that period. And they basically put them in a fucking stranglehold. That's what they did. They put your ancestors in a stranglehold. They mortgaged your estates. Your estates to this day are still mortgaged to back the Federal Reserve notes. And that is part of the administration of your estate. So all these revenue laws are the beneficial use of your property. The lender being able to basically harvest crops from the farmland while the loan is outstanding. Imagine instead of being people that were farmland, which is what we are. That's actually the lawful term for it. And they're harvesting the crops of this land that is held in trust while the loan is outstanding. The lender has the right to the beneficial use of the property. This is in the law of mortgage. And also the property that has been mortgaged is considered dead to the owner. I'll show you guys this crazy shit. Hold on. So we'll hop over here. We'll open a new page. We'll search and we'll just go mortgage. See how important all my tabs and bookmarks and stuff. That's why I keep all this stuff. So definition of a mortgage. Then we go to legal dictionary. And it says, we'll zoom in. The party who borrows the money and gives the mortgage, the debtor, is the mortgager. The party who pays the money and receives the mortgage, the lender, is the mortgagee. Under early U.S. law, the mortgage was treated as a complete transfer of what? Title to your estate. When they mortgaged your estate, the title of your estate. So what happened was originally the states escheated your estate, and you were administered under infancy, and they started to introduce chancery as the primary mode of law, right? The primary jurisdiction of law, chancery, which is basically the enforcement of contracts or private law for the bankers and the business owners and stuff that were basically enslaving the poor in all the states. And then when the 1933 bankruptcy happened, the states pledged their full faith and credit, quote unquote, which is actually all of the escheated estates that they had been busy taking over since they'd been created. And now all these estates were ready to be escheated or to be handed over to be pledged to the United States. The United States took them and pledged them to the international institutions that are lended, like the Federal Reserve. More specifically, you got the Depository Trust and Clearing Corporation that is the one who initially gets your birth certificate, and then it goes on from there. And so this is important, though. The lender was entitled to not only payments of interest on the debt, but also the rents and profits of the real estate. This meant as far as the borrow. So what that means is the lender is not only entitled to the payments of interest, but also to the rents and profits of the real estate. In essence, if it was a farm, then the farm is considered dead to you. You do not get to harvest anything off that farm. The lender gets whatever that farm produces while the loan is outstanding. That's what income tax is on you. That's what revenue codes are on you. Okay. And they're able to do this because they're administering your estate because you're an infant and you've never claimed your estate and taken it out of the federal government's hand and out of the state's hand and became one of the people that ordained and established the Constitution. To ordain is to create, to authorize, and to establish is to write down. And only the people had the power to do that. The government is walking around wearing our clothes right now, our sovereignty, 100%. And this has already been proven that it works, reclaiming your estate, 100%. I've shown it. I've shown it multiple times on here, and I'll show it again before I shut this down, which I'm going to do shortly. But I don't know why I was looking at my skin. Usually I have a watch on this hand, so that was a little embarrassing. But hey, I'm tired. Sue me. So, yeah. So the most important thing I was getting to, though, so he's entitled to rents and profits of the real estate. But this meant that as far as the borrower was concerned, the real estate was of no value, that is dead, until the debt was paid in full, hence the Norman English name mortgage, dead, pledge. Now, bankrupts and mortgaged property like that are considered, check this out, and this is a good old Roman term, civiliter mortis. I hope I spell it right. Pretty sure I did. Nope. I almost did, though. So I get props for that. It's old Latin shit. Civiliter mortis, civilly dead, one who is considered as if you were naturally dead so far as his rights are concerned. Only definition on there because it's so old, but that's what you are. So if we go over here to, say, case text or caseman, whatever, right? Why not? And I put in this term over here. This is my old satanic experiment research I was doing on Denver Bible Church and good old Bob Enyart, friendly pastor Bob, Will Duffy's best friend and mentor, but that's not tonight's thing. So civiliter mortis. So, and it says, so Maddox v. says the court discussed the origin of Section 3-801 and determined that it arose from the common law doctrine that a convicted felon was civiliter mortis. So if you're a convicted felon, I guess you're civilly dead as well. Let's see, there's one about bankruptcy, but by applying this ancient concept of civil death in this context proved difficult because imprisonment so a lot of it's regarding prison, but it is bankruptcy as well. Okay, that's prison. Seems like most of them on here want to civiliter mortis, but it is bankruptcy as well. There we go. Right here. If you guys can see this, I'll zoom in on it for you. There we go. That way I don't look like a dumbass. The bankrupt is civiliter mortis and can no longer sue either himself or another in the name of the assignee alone. That's why they really don't even like to let you use the court system. You always have to have power of attorney. Now, they're, again, because you're an infant and they have power of attorney over you. So that's how the court bonds are actually made. I think I have one of the court bonds in my Law D SD card. If you guys will bear with me, I've got so much stuff on my SD card. I'm going to look and see if that made it through the purge of my last computer that they tried to do. Okay. So yeah, let's pull this up. Is that it? Yeah. No, wait, that's the bond. Okay. Yeah, no, this is it. He requested his bond info, right? And he got the bond info that the court case that he got that he beat the judge over the head with and got $6,800,000 lien on his and 4 other judicial officers' property because they were dumbasses and didn't listen to him when he said he claimed his estate and he was the sole heir and executor. He smacked him in the mouth with common law. This is what a bond looks like. And what they do, look how it says, warning, do not accept this document unless you see a true watermark. And doesn't it look like a birth certificate? Does it not look like a birth certificate? Because your birth certificate's a bond. That's why. It's because your birth certificate's a bond. But back to this. So this is for $11,000. And see the word power amount? Whoever puts up the largest bond controls the court, right? But the crafty thing they do is they create a constructive trust when they call you in there out of the property of your estate, right? Of which they presume you are only a trustee and part of the property of the state, not the heir and executor, not one of we the people, but just a trustee like chattel of the estate that's abandoned and under administration of the government. And they call you in there as chattel, right? As non-living civiliter mortis chattel. So they summon you and you come in and they create a constructive trust with the docket number. And then they take power of attorney over you, as it says right here, power of attorney over you because you're an infant, right? And then they create this bond and they are able to sign for you. It says no, and it's even written in Old English common law way. It says, know all men by these presents, because the very foundation of everything they're doing is still in common law, and it has to be, because that is the foundational, it's just the default law of sovereigns, and it is the fundamental law of the United States Republic, and everything they're doing is in common law. So he says, know all men by these presents that Seneca Insurance Company is constituted and appointed and does hereby constitute and appoint the executing agent, its true and lawful attorney in fact, with full power and authority, sign company's name, affix corporate seal to, and deliver on its behalf as surety, and all obligations herein provided, and the execution of such obligations in pursuance of these presents. So they use you to bond your own court case, right? And then they turn around and make you pay the bond. And then they get to generate untold numbers of securities off of this original security in the first place. The authority of this executing agent under this power of attorney is limited to appearance bonds only and cannot be strewed to guarantee defendant's failure or defendant's future lawful conduct, adherence to travel limitation, fines, restitution, payments, or penalties, or any other condition imposed by the court. So they took power of attorney over you and bonded your own fucking case. It's crazy. Look, they wrote his name and everything. County, Gunnison, boom, 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 right? Attorney in fact. This is whatever the prosecutor signed right here as attorney. And notice how it says attorney in fact, right? Common law. So, well, attorney at law is common law too, but that's when you take power of attorney over somebody, it's attorney in fact. So, but yeah, I thought you guys would find that interesting. We go civiliter mortis and so the bankrupt is civiliter mortis, and this is how they've done it. They did it all through probate, and the Magna Carta opened the gate for it. So let me see what time we're at. 1:06. I'll probably go another few minutes if I can find this quickly. We're going to look for Michigan, the collection of Michigan laws that I have, and I want to show you how they intended on doing this the entire time. So where is there's a whole collection I have. Just bear with me for a second. I didn't intend on going this far. That's why I don't. There it is. Historic Michigan statutes. So now we go back to 1827. Let's go back to 1827, shall we? Actually, why don't we just do that? I probably already have it open. Just do this. 1827, Michigan Acts. We'll just do 1827. It should pop. No? All right, we're going to do it the old school way because we don't want too much dead air, do we? So 1827. This is when it was still territory of Michigan. It takes forever to load too, by the way. But you go down, find the probate, where they created their probate. Notice what's missing from this, though, the Magna Carta, because they weren't trying to use the presumptive jurisdiction of probate yet. They just start with the Declaration of Independence, and then go to the Constitution of the United States, which also has the 13th Amendment, the original 13th Amendment, where they forbid anybody from having a title of nobility on here. And maybe we'll stop by there. Oh no, yeah, here's the bill of Article 12. Article 13, if any citizen of the United States shall claim, accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept or retain any present pension, office, emolument of any kind whatever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. That applies to esquires. That is a title of nobility bestowed by the crown. So not allowed to be in this country as a citizen or operating in our government at all. Eliminate 90% of the government right now, right? I'm pretty sure the only one left would be Trump, probably. I don't think he's a bar attorney. But anyways, this is the ordinance. And now we're going to have to go down to provide a government, respecting, divide the territory, blah, blah, blah. And I have to go down to the appendix because I don't remember the exact page that it is. So sorry about this, guys, but you'll find it interesting. So probate. Where are you at? It's going to be down a little bit further. P. There we go. Probate bonds. Look at this. Isn't that interesting? An act establishing courts of. So that's going to be page 55. Let's go up to 55. So that's number, boom. No, is that not 55? What page is it? Oh, 46. It's not lining up with what it says on the side of the screen there. 55. So be it enacted by legislative council. So an act for establishing courts of probate. Be it enacted by the Legislative Council of the Territory of Michigan that a court of probate shall be held in each of the several counties of the territory, of this territory, and there shall be some able and learned person appointed in each of the said counties as judge. So nothing in the ordinance about this, right? They just automatically assume, well, you know what, we need probate. We're not even a state yet because they planned on escheating the estates of everyone in the state before they even became a state. This was their entire plan the whole time. And look what it says. It says, appointed in each of said counties as judge of the said courts, respectively, for taking the probate of wills and granting administration on the estates of persons deceased, having been inhabitants of or residents in the same county at the time of their decease, for appointing guardians to minors, idiots, and distracted persons, and for examining and allowing the accounts of executors and administrators and guardians, and for such other matters and things and laws. So then we'll pop ahead a little bit to 1836. Okay, why not? Why wouldn't we? Right, so this is right after we ratified our Constitution, we were becoming a state. So now we have a Constitution. Constitution says nothing about probate because they don't have to. It's part of common law, right? It's taken for granted. So now we're going to go all the way down to the appendix real quick, just so we can find which page the probate's on. And I'll tell you what, navigating on these old historical sites is a pain in the ass because of this right here, like how fucking long it takes to load anything. But this should be the appendix, I believe, right here. Index, yeah, whatever. And then we're going to look for probate. So, or maybe I went too far. Yeah. So that was the index. We need the appendix. Bear with me. But this is funny. So 1827, they authorized building of certain dams, act of blah, blah, blah. List of laws. Okay. Where the fuck is the appendix? I found it before. Promise you guys. Basically, this is where they grant license to the probate court. Okay, yeah, we're gonna have to do it this way. So, yep, P of Attorney General, Branch County, blah blah blah. And where the fuck is P? Oh, I was looking on the wrong side. It's probate. Okay, we got it. It's 116, guys. 116. All right, page 116. So now remember, they created the probate before they even became a state. And now they're going to figure out how to start distraining people of their property and selling it. Because that's the name of the game. It's fucking the poor people are chattel. And, you know, people who do not know the law are chattel. And that's just, you know, 116 though. Yep, so right here. An act to authorize the conveyance of certain lands. Now, the word conveyance is sale, essentially. It's giving away or selling. It's conveyance. So now we're gonna zoom in a little bit on this. Be it enacted by the Senate and House of Representatives, and notice it doesn't even say anything about probate in the title. I had to go to the index to look at it, right? So be it enacted by Senate and House of Representatives of the state of Michigan that Honorable McManus, guardian of the minor children of James McManus, late of County, blah, 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 to execute in due form law of Thomas Center, blah, 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 right? And right here, no, this is it. Being enacted by the Senate and the House of Representatives that Andrew C. Fry, under 21 years, is hereby authorized to. So maybe this isn't the one where they granted the license, but it is. You guys get the idea. And then by the time, oh, here it is. Yeah, an act to author. See, I know what the fuck I'm talking about. An act to authorize judges of probate to grant license to sell the real estate of minors and others, right? So that the judges of probate in their respective counties may, on the representation of any guardian of any minor, idiot, lunatic, non-compos, means mentally incompetent or distracted person, grant a license to such guardian to sell at public auction to the highest bidder or at private sale, as the judge of probate shall consider will be most beneficial to such minor, idiot, lunatic, non-compos, or distracted person, if said judge shall be of opinion that such sale will be for the interest of the minor, idiot, lunatic, non-compos, or distracted person. See, now, what they don't tell you, because they don't have to, because this is all based on the Magna Carta, is that the administrators are allowed to take a fee, a reasonable fee, which they have determined is over 30% for administration. That's why they want to administrate. That's what Title 4D of the Social Security Act, creating the child support and the entire front of the court racket, that's why they're so incentivized to get as many broken homes, two-parent households that they can, so that they can take the estate under administration and collect a fee for administrating the child support case. So now that I've probably gotten you guys thoroughly depressed, and so when you fast forward all the way up here to where are we at here? This one? Yeah, this one. The compiled laws of the state of Michigan with this is the only place you can actually find the true probate code of Michigan, because they have repealed it and omitted and removed everywhere online any copy of the probate code that they still follow right now. And they don't want you to see, because the first sections of it are all about decedents and infants and how to take control of the estates and all that stuff. And maybe we'll go into that one on our next law class if you guys would like. But as I have been running for about 2 hours now, right? I think I'm going to shut it down. because this is a lot of heavy information. I want to give it to you guys in digestible portions. I'm treating this, very seriously. Not that I wasn't before, but now I'm treating it like a job. Like this is a job. I'm going to give you guys my best every time. I even up to my production value, right? And I just want you guys to really learn this stuff, be interested in learning, and I want the quality of the show I give you to match the quality of the information I'm giving you. And I hope that it does, right? So, I know the information I'm giving you is solid. So one last thing before I close it down, because as I said, I'll prove to you that that this is true. So it's Colorado Secretary of State website, right? This is from a man who claimed his estate. The judge tried to take him to court for some bullshit. He told him, hey, you can't administer my estate, and I have no contracts with the state, and you're not above me, and you have nothing to do with me, right? You need to take me to a common, if you want to file something personally at common law, personal grievance, you can do that. But yeah, I'm not chattel. And so, and that's just the sum of it. It's not, you put it much more eloquently. So the judge didn't listen. He took him through he filed a counterclaim on the judge at law, though. So the judge has him in equity, which is an inferior court. He went down, filed with the clerk an at-law counterclaim for trespass on his estate, trying to drag him into a contractual jurisdiction when he has no contracts with the state, right? And he took him through the administrative process because, or the due process, it's called administrative process, because the judge didn't take him seriously. He sent him first, second, third notice, found him in dishonor, defaulted him, took the judgment common law to the Secretary of State, filed it, and the Secretary of State put a common law lien on all the judge's property. Then he turned around and took that and went to arbitration, which is private court in this country. It's all private right now, but this is actual, known private, you go hire an arbitration company to settle a dispute. That's what arbitration is. It's ancient Roman. It's almost like Roman common law, but Rome doesn't have a common law, but it's the most ancient Roman form of law still in existence to this day, and they all have to honor it because they're all Roman civil law servants, essentially. So took him to arbitration and got the award. His name is Daniel A. Wazzle. So just so that we're all clear, we'll go over here and just put in his name so you guys can see he is a judge, because Wazzle. Whoops. Yeah, well, whatever. It fixed my typo. So look at this. Evaluation, Colorado Office of Judicial Performance and Valuation, Wazzle, Daniel, right? Same guy. And there's actually 3 other court officials that he did this to. So I can do some images, probably pull up his picture and oh yeah, I have no idea who he is out of that. But over here in the search though, Trellis Law, coloradojudicial.gov, Colorado Judicial Branch, Daniel Wazzle, right? Alamosa Combined Court, Independence Way, et cetera, et cetera. So this is him. Let's go back here. We're going to go ahead and search his name, Daniel A. Wazzle, right? Whoops, get out of here. Search. And sometime today it'll pop up with the results, maybe. Or is it going to be a dick? It does this when I try to show it on the internet. I swear, almost every time. You can ask my regular subscribers. So we'll try this again. We'll go to UCC. No, where the fuck is we'll go forward again. Okay, standard search. Yep, Wazzle. Search. There it is. Popped up. Okay. Now we got to wait 45 years for this thing to show up. It's getting there, though. No problem, John. I appreciate it, man. I appreciate you guys. Thank you for learning. It's important. I wouldn't be doing this if you weren't here. You're already in feudalism. You have to get absolute claim of your title because it's called bifurcation of a title, splitting it in two. So, but yes, no, titles don't necessarily put you in feudalism. There's titles pre-exist feudalism, but registration puts you in feudalism. So Anyway, so this is the arbitration award right here. Okay, so we go in, we zoom in here. We got, and this is on the Secretary of State website. Okay, and she had to put it on here because he is, let's see if I can pull up the full thing over here. You know, open. I'd rather look at the full. There we go. This is much easier to see. Yeah. A little bit of nicotine, right? While we wait. Holy shit, dude. It's not that big. It's not that big of a file. See, this is what leads into you will own nothing and be happy. You will own nothing and be happy. Holy shit. This thing is taking its sweet fucking time. All right, there we go. So you see this. This is the debtor. We'll zoom in on this much easier. Walzel, Daniel, Austin. This is the judge, right? There's the Alamosa, where we seen he was a judge. This is the guy who did it. It's Brett Nelson, okay? As per Colorado revised statutes 13-52-102, all goods, chattels, lands, tenements, and real estate of the four debtors, because it's not just the judge. You got two other court officers, and I'm pretty sure the officer himself that arrested him, are brought forth as lien security, right? As per UCC 9-609. See public record document, San Miguel County, Monroe County, blah, blah, blah. It says the collateral is related in part to real estate as per Colorado revised statutes 1352-102. Debtors owe $6,898,000 as per the unchallenged negotiable debt instrument. And here's what he has: his birth certificate claim, his where is it at? Yeah, the birth certificate claim is essentially the claimant title. Essentially, the way they did it was a little different. I don't think it needs to be separate from the claimant title myself. So you go down here, and boo. He wrote his claim of title the same also as a performance contract. So when the judge started to administer his estate and he was given notice that he was entering a contract and continued to do it, he became bound as a trustee to Drew. And that's how you do it. Right. But this is written not very great, but it still worked because the bones are good. And that's why I'm almost done with mine. I'm rewriting it in a just no offense to them, because it worked. Look, you got a fucking almost $7 million lien on these guys, but so it worked. I'm not knocking them, but I'm just it's a little redundant in a lot of places. It can be shortened up, made more concise, and just written better. And that's what I'm in the middle of doing right now. But it works. So, and you know why it works? Because this is exactly what they're fucking doing. They're administering your estate. They escheated your estate under presumption, and they're administering it. They've mortgaged it to back their entire international security scheme that they're doing right now. The Federal Reserve notes, the stock market, the bond market, your companies, when they get you to sign up for 401k, it's like private social security slush fund they get to borrow against. It's the corporations are all in on it, because really it's just one big fucking corporation. That's what it is. So, yes, it is. I don't know if you said feces or fasces, but that is what it is. So, yes, you go to coloradosos.gov, go under UCC, look up Daniel A. Well, you have it's recorded on the internet. Just go back and redo what I just did. If I link it to you, it's not going to bring it up. It always goes connection failed, server. So I downloaded it. It's on my phone, and actually I'm going to save this on my computer right now. Yeah, we're going to put it in downloads. We're going to label it Walzel, WALZL, lien. But if you do not know how to use it, you're going to get fucked. That's another. So you can go look this up. Absolutely. See, look, it won't even let me download it. That's insane. Yeah. Well, it's on my phone and I've printed it, so I don't care. Fuck them. But if you do not know how to actually stand on this information and understand entirely what I've been trying to teach you, how to stand on it, what's being done, what the judge is, how this actually works, and why it works. You have to know the history of law. You have to know the history of common law. You have to know the things I'm teaching you, like inside and out before you go in and get this to work. But it works. Just a forewarning. Okay. I just want to warn you. So I'm not responsible if you go try to use this and you think just by filing it, but you have no idea what it means or what's going on and they steamroll you. That's not my fault. You see it works. I just showed you on a government website it works, but you have to learn. And I'm willing to teach, and that's what I'm doing. And once I finish my document, I'm willing to figure out how to get that to you guys, but only to serious students. That's the big thing. It's only going to be to serious students because I'm not going to waste my time with people who aren't going to use it properly. And it's not something to just be trampled over and get, you know what I mean? Like then it's not going to work that way. But serious students only, we're going to figure that out. I'm almost done with mine. But I just figured I'd show you guys that at the end of the night so that that further solidifies, reinforces everything I've been telling you. This is how it works. It works. You see this right here? You guys see this? $6,898,000 leaned against these bastards because they kept administering his estate and fell into his trap, his performance contract. So. All right, let me stop sharing the screen. We'll go through a few comments here. Yeah, sure he did, Lazarus. Yep. Yeah, okay, Lazarus. That's why. Come on up, buddy. I'll put a link in the chat here. You want one? Hold on. Hold on. Come on up and have a debate with me, you little queer. You don't even know what the fuck you're talking about. Here. Oh, wait, you know what? I got to go to the Rumble side, don't I? Hold on. Just wait there. I'll be right with you. Here you go, douchebag. Why don't you come on up here? Why don't you come on up here and have a conversation? No, absolutely will not. So come on, buddy. You coming? I'm waiting. Where you at? I don't see anybody backstage. That's right, because you're a little bitch. Shut up. Get the fuck out of here. Anyway, so offer to debate is always open to any lawyer, to anybody. I don't care. And if you think that I do not know what I'm talking about after all the years I've spent learning this, please feel free to come up here and tell me. We'll see. We'll see how much you know. Where are you at, bro? Are you coming up or no? Yeah, that's what I thought. Anyway, let me say goodbye to the people I'm actually here for. So let me look and see what we have. Great show. I'm glad you enjoyed it, Dead and Drumming. John Keeley appreciates it. Thank you. Yeah, definitely go back to part 1 if you just started in on this one. Could set up transcripts. I think YouTube also just makes transcripts of the videos. I just noticed that today when you click on the, like where it shows the views and all that stuff, you click on that, it's got a transcript under it. And it actually, like AI, it's kind of creepy. That means AI is like actually creating a transcript of my voice. It's a little weird, but lawyers must be prohibited by the bar from pursuing. Oh yeah, absolutely. Yes, they'll get disbarred so quick. Game needs an update. It's poop. What's that mean? Theirs, or not really sure what you mean, Flurfy. Bullet says thanks. No, it was not wanting me to show that, Mike. Not at all. It never does. And yeah, again, Jace, just go to sos.gov, or, just put in Colorado Secretary of State and just rewind this video. It's Daniel A. Walzl, W-A-L-Z-L. And you can check it out there. Just be prepared to wait forever for it to load. And what do you do after you get the lien? Well, that's the question, isn't it? It's, well, you can use it as a security. Why couldn't you? The same way that once they get a lien on you, right, they can use that as security. Why couldn't you use it as security to make promissory notes? You could probably take them for a garnishment if you could find any judge to play ball with you. I mean, but most importantly, their entire property is locked up. They can never do anything with it. He can never sell his house. He can never do anything with his house. It's got a lien on it. It's got a $6,800,000 lien. So Let's see here. There's that little queer. Didn't want to come up here. Are you going to come up here or no? Yeah, David Lester Straight is an admitted CIA agent. Carl Lentz is a retard. Are you fucking kidding? Dude, you are an absolute moron. Like, fuck, I like, really? You know, this guy's big problem is he's an atheist, and he hates when I tell people that the sphere of the law is spiritual, and his name's Lazarus Wolf. What are you, some kind of goddamn devil worshiper, dude? Shut the fuck up. Anyways, you guys have a fantastic night. I hope you enjoyed the presentation. This little queer, not going to come up here because he's a bitch, so not going to waste any more time waiting for him to do that. And I will see you guys Monday morning. The law book that we should have Blackstone's commentaries, man. Absolutely. Blackstone's commentaries. Everybody get Blackstone's commentaries. You can probably find a PDF online for real. I would imagine that buying it is going to be grossly expensive, but you can probably find one online. It's old book. It's not copyrighted. I highly doubt. So anyways, you guys have an excellent evening. Thank you for learning, and I hope this helped. And if you guys want a part 3, if you want me to go further into how the probate code's created and expressed, particularly, I can tell you in Michigan, because I've traced it from its origin all the way through, that when they blended all the jurisdictions in the Michigan compiled laws, that's why they call it compiled laws now. It's not just common law like it was before. In fact, in the Judicature Act in 1914, they said they wanted to basically move away from common law because it was cumbersome to bounce around from, because attorneys are notoriously lazy. That's why. And because they don't want you to have your natural rights or your absolute claim to your estate. So just let me know what you guys want to do. What we're going to go next. We'll be back on with the morning PSYOP breakdown on Monday morning. Yeah, Monday morning. And I will see you guys then. All right. Till then, be safe and learn the law, dude. Just read some of this stuff. Blackstone's commentary, for real. All right. Have a good night, guys, or morning, wherever it's morning here now.